Hello, everybody. Thank you so much for joining us today. My name is Juan Carlos Brando, and for me, it's a pleasure to have everyone here joining us in this show with one of the attorneys in the law firm of Margaret W. Wong and Associates. Well, today is a good day. We are already on May 18, and well, it's good to know that people are more aware about immigration, about what's going on in the immigration field. And of course, you can have an answer for any question that you may have in regards of the immigration world. So let's welcome the attorney Francis Funson today. He's going to be talking about some of the immigration latest news, but also he's going to be answering your questions. So please feel free to write it down, to write your questions down on our Facebook Live or our YouTube Live. And the attorney Francis Fonsen, with all of his experience, will answer each and every one of your questions. Let's welcome him. Hello, attorney Francis. Thank you so much for having us today. How are you doing?
I'm good, thanks. Thanks for having me.
Thank you so much. Attorney Francis, well, a lot of things are going on in the immigration world in this last week or two. But one of the interesting things are the end of the Title 42, which we spoke last week. But why are people trying to get in with this Title 42? Because as I understand, this is something related to health because of COVID-19. But people, according to Title 42, were supposed to remain in Mexico. So why are people so scared about the end of Title 42?
Well, so Title 42 is based on protecting the country from health-related issues. So the previous administration, the current administration, was using the COVID pandemic as a reason to prevent people from coming into the United States across the southern border. Now, because the pandemic is officially over in the eyes of the government, the US government, a lot of people are afraid, well, this is going to be a security issue at the southern border because this way of preventing people from entering has been removed. Now, there's always been a way for people who are approaching the southern border, who say, I want to apply for asylum, I'm afraid to go back to my country, to receive what's called a credible fear interview to see if they're eligible to pursue that asylum in the United States, okay? And so that has always been there. So that doesn't change whether it's Title 42 or not. But now that Title 42 is ending and the administration is afraid that there's going to be this huge influx of people coming to the border, they're passing these more restrictive border requirements to make it more difficult to apply for asylum. And they're trying to expand what are called lawful pathways, legal ways for people to come into the United States, which is what we're hearing about, these parole processes for Colombians, for Venezuelans, for Haitians, and all these other people, legal ways for people to come so they don't have to cross the southern border.
Okay, so maybe could I say that probably this is not as bad as it looks?
Right, it seems this is maybe more of a political situation. And maybe they're trying to anticipate this huge influx of people coming to the border, okay? This new policy has only been in place for about a week now. And so we don't know what the actual effect is going to be.
If I come illegally to the United States and try to cross at the border, let's say I surrender at the border, can I apply for asylum?
Okay, well, under these new rules, the recommended procedure is to use the CBP-1 app. It's an app on your phone to schedule an appointment to come to the border, and then you won't be subject to these more restrictive requirements. Because if you try to sneak across the border without using this app, and you are caught by immigration, you'll be expedited, removed. That's an automatic deportation, and it'll make it much more difficult for you to come into the United States later, even if you have a method to come through legally.
can I claim asylum at that point before they expedited remove me?
Well, technically, under these new rules, they say that you should not be able to apply for asylum if you're caught after May 11th crossing the border illegally. That's why it's much more important. If you're already in the United States, that's different. But if you enter after May 11th, then you should try to use that CBP-1 app. Now, there is an exception. If there are exceptional circumstances where you're fearing for your life, you'll be killed, you'll be raped, there's some urgent situation where that's why you had to enter illegally after May 11th, then you're eligible to do that credible fear interview and asylum in the United States. But that's completely up to that officer's discretion. They might say, oh, it's not urgent enough. It's not exceptional enough. And so it's risky. But if you're fearing for your life, then you do whatever you have to do.
Okay, perfect. Thank you so much, Attorney Francis, for this answer. And don't forget that you can call. The office number is 216-279-3984. 216-279-3984 is the phone number that you need to call in order to make an appointment with one of the attorneys in the law firm of Margaret W. Wong and Associates. So please don't forget that you can call 216-279-3984, 216-279-3984. About the Colombian, Guatemalan, Honduran and Salvadorian parole. Is this the same as the Venezuelan, Nicaraguan, Haitian, Cuban, and Ukrainian, or is it different?
No, this is a little bit different because Ukraine and Venezuela, there was an urgent humanitarian crisis in those countries. And so there's an urgent need for people to leave, okay? And so these are Colombian, Honduran, El Salvador. These are a lot of the individuals coming to the southern border. So the Immigration Service is trying to come up with lawful pathways to come in. Now, there's no details yet. Right now, the Immigration Service has said, if you are a beneficiary of an approved I-130, that means a US citizen or permanent resident relative has filed an I-130 petition for you, then you and your family members might be able to come into the United States earlier using this parole process. Now, you have to be invited to enter. So this doesn't mean you come to the southern border. This doesn't mean you apply for the parole directly. The National Visa Center will reach out to those US citizen and permanent resident petitioners to invite them to submit the parole process. And so we're expecting an update with that within the next couple of weeks, around middle of June. So keep an eye on the uscis.gov website for those updates.
Okay, that's perfect. And thank you so much for this information, because a lot of people are thinking that it's the same process with the I-134A for Venezuelans or for people from Nicaragua or all of the other countries. So thank you so much for this information. We have a question here, which is very interesting. It says, I am from Guatemala. I entered to the United States on an agriculture visa. I work in Iowa, and then I moved to Florida. My status expired 2 years ago. What's going to happen with me? Should I move out of the state of Florida, or there's a chance for me to find another employer to hire me and keep my visa?
Well, first of all, there's this new law that everybody's going to hear about in Florida. We haven't really seen what the effect of that law is going to be. Right now, there's a lot of fear because of the unknown. We don't know how the Florida state officials or the police or safety people are actually going to enforce this law. Now, on the immigration side, because you overstayed the visa more than 2 years, that means you can't just transfer that visa to another employer now, all right, because you've already overstayed. And if you leave the United States, because you've overstayed more than 1 year, you can't come back for 10 years. You would have a 10-year bar. So unfortunately, it's going to be very difficult for you to get legal work authorization or to get another type of this agricultural visa. And so, I mean, that's the difficulty with somebody overstays their lawful status. They wouldn't be able to change or extend or to transfer that status.
Okay, perfect. Thank you so much, Attorney Francis, for this answer. Don't forget that you can call the offices. The phone number 216-279-3984, 216-279-3984. Hi, my I-94 for asylum grant messed up. How can I get a new one?
Okay. So if there was a mistake, so if you are granted asylum by an immigration judge or by the USCIS asylum office, then you would make an appointment. You would receive a paper I-94 that says your asylum is granted. Okay, and you can use that to work and to apply for identification and all of that. Now, if there's a problem with that I-94, then I would suggest and you need a new one. Okay, then I would suggest you make an info pass appointment. That means you call the USCIS customer service phone number, or you go online to the USCIS website to make an info pass appointment in person to go to your local immigration office, explain that you don't have the I-94 anymore and that you need a replacement. Okay. Now, that is only if you need that I-94. Typically, after your asylum is granted, after 1 year, you can apply for the green card. That means filing an I-485. You do not need that original to apply for the green card. A copy is fine, or even a copy of the judge's order is fine. So you only need that original if you're going to use that to work or to apply for a driver's license or something like that.
Thank you very much, Attorney Francis. Don't forget that the phone number is 216-279-3984, 216-279-3984. Attorneys in the office of Margaret W. Wong and Associates with over 46 years of experience working on this immigration field and helping thousands of people get an immigration relief in the United States of America. So don't forget, they are attorneys in the United States of America, no other countries, but they are nationwide here. So the answer is you need to call the office with the experts in the immigration field. 216-279-3984, 216-279-3984. Hello, when I apply for asylum, am I able to file for labor cert?
Okay. So labor certification is the first step in the employer-sponsored green card process. If you are working and your employer is willing to sponsor you for the green card, then there are 3 steps. Labor certification, which is when we advertise the job in the local newspaper to see if there are qualified other U.S. workers for that job. If no qualified U.S. workers are found, the second step is the I-140. That's the employer petition. Okay. And the third step is the I-485, which is your personal green card application. You and your family can apply for the green cards. Okay. Now that very first step, labor certification, technically the employer can do that whether you are in the United States or outside of the United States, whether you're lawfully here or illegally here, because that is just a test of the local market. It's an advertising process. Similarly, with the I-140, it doesn't matter whether you're legally here or not. That is just to prove whether that the employer can actually afford to pay you the salary and whether you actually qualify for this job. But it's the last step that's most important. Can you actually apply for and be eligible for the green card here in the United States? Okay. Now, if you apply for asylum, that is technically not a lawful status. If your asylum is pending, you're waiting for an interview, waiting for a decision, it doesn't mean that you have lawful status. It's not like you have a visitor visa or student visa status or H-1B or some temporary status. It's just a pending status. Now, you are not illegally here. You don't have any unlawful presence while you are waiting for that asylum case, but it doesn't mean that you can just qualify for employer-sponsored green card process. Now, if you came to the US legally and you applied for asylum while you were still legally here and you were waiting for your asylum to be processed, then it is possible that you could do the labor certification, the I-140, and the green card application here in the United States. But if you came legally or you came illegally, you overstayed your status by more than 6 months, then you filed the asylum application, you would not be eligible for the labor certification green card process. All right. So it's a lot of explanation, but just filing that labor certification isn't really going to help you if you can't get to step 3, the actual green card application.
Awesome. Thank you so much for your answer and for every detail that you just gave, because this is kind of a tricky question. When I applied for asylum after the 6 months, what happens? And what happens if I applied within the year? Um, so for just for a clarification, if I apply before 1 year, I qualify to apply for asylum. Is that right?
That's right. So that's the
Okay.
asylum rules, not green card application rules.
Okay, perfect. So that's asylum rules. So if I want to apply for labor cert, I have to apply before my I-94 is expired.
It's best if you can. It's best. It's if you apply for asylum before your I-94 expires, then you have a much better chance of going through the green card process through labor certification than if you overstay your visa. Now, if you have less than 6 months of unlawful presence, that means there's a gap. The problem with immigration is there's those gaps. Your I-94 expires, then you file asylum. There's that gap of illegal time. That's the problem. If that gap is less than 6 months, maybe you're okay. But if it's more than 6 months, that's definitely a problem.
Okay, perfect. That's I really like that answer because that clarifies a lot and what we are doing in uh, advising people or telling people a way to do their case if they are applying for asylum and all of the chances that they have. So if you have any other question, please just call the office 216-279-3984, 216-279-3984. I entered in 1996. I have 2 children born in the United States. My dad used to be a green card holder. How do I know if I qualify for 245I?
Okay. So usually, if you enter the United States illegally, you can't apply for the green card here in the United States. You would have to go back to your home country, go through the US Embassy in your home country, and maybe if you've overstayed or you've been illegal more than 1 year, you need a waiver to forgive that illegal time called an I-601A. Now, there's an exception to that illegal entry rule. If you qualify under the law called 245I, then it doesn't matter if you entered illegally. It doesn't matter if you overstayed your visa. You could get the green card here in the United States, assuming that there's someone to sponsor you. Okay. So how do you qualify? There's 2 ways. Either someone filed a petition for you or for your parents before January 14th, 1998, or the second option, someone filed a petition for you or for your parents between January 14th, 1998 and April 30th of 2001, and you were physically in the United States on the date that law passed, which is December 21st of the year 2000. So for an example, your dad used to be a green card holder. How did he get the green card is the most important question. If he got the green card through amnesty, that means nobody sponsored him. He just applied. So that doesn't help you get 245I. If an employer filed a petition for him, for example, a labor certification to sponsor him, and that was before 1998 or before 2001, and you were already born when that labor certification was filed, then you qualify for 245I as well, because you were already born when that employer filed for your father. So that's the first question. How did your father get the green card? The second question, did your father ever file a petition for you or for your mother as a green card holder? If your father filed for you, before the year 2001, before April 30th of 2001, then you qualify for 245I as long as you were physically present in the United States in the year 2000, which you entered in 1996, so you should be fine. If your father is a green card holder filed for your mother, then you are automatically included in that petition. So that means as long as your mother was here in the year 2000, then you are automatically qualified. Okay, so it's a little bit complicated. If you're unsure of what happened with your father or whether you qualify, definitely visit us in our office for a consultation.
Thank you so much, Attorney Francis. A person is asking, where can I send my questions? Can I send it to your inbox? Yeah, you can send them to our inbox, or you can send it right here, and we can put it in the show without showing your name, or we can do it. You can do it directly. So, however is best for you, we can just ask the question as we usually do. If you see all of the questions, those questions are from someone. Some of them, or most of them, don't want their names shown in the screen, so they write it down in our inbox, and then we take care of the questions. Okay, next question is interesting. We have a bunch of questions here coming in through the show. Ha Lee says, I am U.S. citizen. When I lost my U.S. citizenship, can I still receive my Social Security benefits?
Well, I mean, the first question is, did you actually lose your U.S. citizenship? Because it's very difficult to lose citizenship. Either, number one, you abandon it. It's very difficult. That means you have to actually renounce your citizenship. There's a procedure to go through the U.S. Embassy, to renounce it, sign a lot of papers. Or number two, did someone take your citizenship away from you? For example, if you never should have qualified, and then the U.S. Attorney's Office, the U.S. government files criminal or civil case against you in federal court to strip you of your citizenship, then you lose it that way. Otherwise, just because you go overseas, spend a couple years overseas, that doesn't mean you lost your U.S. citizenship. You are still a U.S. citizen. Now, when you lose your U.S. citizenship, you still receive your Social Security benefits. I would say those benefits are earned over your lifetime. And so you should still be able to receive those benefits. Now, we are immigration lawyers, not Social Security lawyers. So I would suggest you double check with a Social Security lawyer. But in general, these benefits are earned. You don't lose them just because you go overseas. Okay?
Maybe this person is confused about the green card, that you can lose your green card because you spend too much time outside of the United States. Because that's something I know, that you can lose your green card but not the citizenship. But yeah, maybe you just need to call the office, and the phone number is 216-279-3984, 216-279-3984. Yeah, this person is asking and saying that, well, it will be too public. Well, you can ask the question either on our Facebook inbox, or you can ask the question in our Instagram inbox. The Instagram account is Margaret W. Wong and Associates, and you can send it to our direct message, and we will just read it and ask the question live, so nobody will see your name on the screen. Next question is, hello, sir. Please, what documents do I need for to file for I-730 for my spouse and son?
Okay. So if you are granted asylum, either through a judge or through the asylum office, you are allowed to bring your spouse and minor children into the United States, or they automatically qualify for asylum if they're physically in the United States. And so to do that, you file an I-730 for them. Now, what documents do you need? You need a copy of your asylum grant, whether it's from the judge or whether it's the I-94 from the asylum office, okay? You need documentation to prove the relationship to your spouse and son. You need that marriage certificate, and you need the birth certificates of your children. okay? And you should have some sort of identification document if your spouse and son have a passport or other identification, okay? So these are the minimum documents required. Now, it's very important that you file the I-730 within 2 years of your getting asylum approval. If you wait longer than 2 years, it's very difficult. You would have to show extraordinary circumstances why you filed late. So definitely file within 2 years.
Thank you so much, Attorney Francis. And we keep receiving more questions. This next one, and we only have 4 more minutes. Next question is, I am U.S. citizen. My husband is Venezuelan. He just got his green card. He has 2 kids, 14 and 10. What is the best way to bring them to the United States? I would like to help them come and reunite with their dad.
Okay, so there's 2 ways for them to come. Number 1, because you 2 married before the kids turned 18, those 2 children are your stepchildren. That means you could file an I-130 for each of them to sponsor them for the green card, okay, just like you filed for your husband. Or your husband could file as a green card holder I-130s for each one of them, okay? So which is actually faster? Which is the better way? Well, the cost is about the same because you need 2 I-130s, 1 for each child anyways, whether it's from you or from your husband, okay? If your husband is filing for them directly, well, then he just has to prove his relationship to them. That means, are they his children? Is his name on their birth certificate? If you file the I-130s for them, you have to prove that you and your husband are still legally together, married, and living together with a real relationship, and you prove his relationship to them. So it's probably more straightforward if your husband files the I-130s for those 2 children.
Thank you so much, Attorney Francis. We want to ask your question, but you can just go to our Instagram account, write a direct message, which is going to be private, and we will just read it without saying names or saying any details about you. Meanwhile, I'm going to say the phone number that you need to call. The phone number is 216-279-3984, 216-279-3984. Also, I wrote down my email, juancarlos@imwong.com, juancarlos@imwong.com. You can write your question there, and I'll be happy to read it in the live show either today or next week at the same time. So thank you so much for joining us in this show. Okay, so we have more questions here. I am U.S. citizen with 2 kids. How long take the process? My wife lives in India. How long would the process take?
Okay, so if you're a U.S. citizen, you can petition for your wife and for the kids to come into the United States. Now, if she were a permanent resident, you can file 1 I-130 to cover everybody. But because you are a U.S. citizen, you need to file 3 separate I-130s, 1 for your wife, 1 for each child. How long will it take? It'll take probably about 1.5 to 2 years, okay? It'll take about 12 months to get the I-130 approved. It'll probably take around 6 months to get the case what's called documentarily qualified. That means the file is transferred to the State Department National Visa Center, the NVC. You upload the necessary documents to the NVC website, and then you wait for the NVC to review it. After the NVC reviews it and everything is fine, then you wait for that interview to be scheduled at the US Embassy in Mumbai, India. That is where the delay might happen. There's so many people waiting for interviews throughout this whole pandemic because of the delays that it might take you 3 months, 6 months, 1 year, 2 years sometimes to get that interview. Okay, so the important thing is file the I-130 as quickly as possible, get this process started.
Thank you so much, Attorney Francis. We had an awesome show today, a lot of questions coming in. But don't forget that you can call the office directly to make an appointment in one of the 7 cities that the office has locations in Atlanta, Cleveland, Columbus, Chicago, Nashville, New York, and Raleigh, North Carolina. And the phone number is just 1-216-279-3984, 216-279-3984. Attorney Francis, thank you so much for having us today. I'll see you next time, and have a good lunch.
All right. Thank you.
Thank you so much. And please keep joining us in our shows. And if you don't want your name to be shown on the screen, please just write us an email or write in our inbox on our Facebook page or our Instagram account, and we will be happy to write your question on the screen. Not names. We won't say any names, no identification, and we will be happy to answer your immigration questions. The phone number, if you need more information, 216-279-3984, 216-279-3984, the office of Margaret W. Wong and Associates. Thank you so much, and see you next time.